Get on the train before it leaves the station. The truth train is coming, gonna run them down, run them down.
Hello there, folks. How you doing? Here we are today again talking about another wrongful conviction. And like I've done before, I'm going to put in some other clips to illustrate some other points about wrongful convictions, other wrongful convictions that are similar to some of the aspects in the case we're going to talk about today. Now, the case that we're going to be going over today, or that we're going to be looking into, I should say today, is the Daniel Holtzclaw case. Now, right off the top, I want to say to anybody out there, you know, if you believe Daniel's guilty, if the press on this convinced you, then I just ask you to give me about 45 minutes to an hour to just go through this. Give me the benefit of the doubt for that amount of time, and if afterwards you want to go back to believing he's guilty, I have no grudge with that. But I want to go over something here that I think is quite interesting, that I think points out a lot of issues with the Daniel Holtzclaw case. And I think the fact that the media was so involved in this one, you know, is another aspect that really ties into my coverage of Trial by Media on Netflix. So yeah, there was a lot of press on this one. I remember hearing about this one back when it was happening, but it was before I got into, I think it was either before I got into Avery Dassey or when I was just getting into, you know, studying the documents and stuff for Avery Dassey. But anyway, I do remember hearing about it. So I know that it was, you know, very big in the media, right? And it's even mentioned in the paper that we're going to be seeing here today. So there's that trouble that the media was so heavily involved. And the media, it's clear from this paper that I'm about to read that the media wasn't conveying everything. The media was actually being somewhat selective in what it was doing. And we all know that the media, again, is another one that parallels with the Avery case. You know, because the media and the press around Avery Dassey was just, you know, off the charts, right? And so that's another parallel that you can draw between Daniel Holtzclaw and Avery Dassey. Now, some of you out there may be saying, oh, wait, but hey, whoa, Avery Dassey haven't been exonerated. And to those folks, I'll say only this. Wait for it. Yeah. So it's pretty obvious for me to, you know, I want to point out the earmarks of a wrongful conviction. And the paper we're about to go through basically goes through line by line of all of the things at trial and in the investigation that were, you know, that are very similar to other wrongful convictions, and how, you know, prosecutors and investigators get it wrong. It's, you know, there's a lot of examples here of the investigators and the prosecutors, once again, getting it wrong and not doing it properly, to be sure. And you'll see that here when we go through this paper. So this paper that we're going to be talking about is written by basically the private investigator that was hired by the defense attorney that was representing Daniel Holtzclaw. And you know, his name is Brian Bates. He has his own PI agency. He's basically going to talk about in the beginning here how he was basically doing a blog. He actually covered a lot of cases of police brutality, or, you know, overuse of force and stuff. He was very much of an activist, trying to point out when the police were overexerting force and that sort of thing, right? So I thought it was number one interesting that he comes from that background to begin with. But Daniel Holtzclaw's defense attorney had contacted him, and he explains it here in the letter. And in fact, I'll let him do the explaining of that right here, and then we'll come on back. The Daniel Holtzclaw allegations, investigation and trial, a closer look. On 1/24 of 2016, by Brian Bates. On January 21st of 2016, former Oklahoma City police officer Daniel Holtzclaw, 29, was sentenced to 263 years in prison after an Oklahoma County jury found him guilty of 18 sexual assault-related crimes against 8 female accusers. Holtzclaw was acquitted of 18 other sexual-related crimes against an additional 5 female accusers. What comes next, I've written and rewritten dozens of times in an attempt to accurately, concisely, and fairly portray what I personally witnessed in regards to this investigation, trial, and aftermath of the state of Oklahoma versus Daniel Holtzclaw. I'm not simply going to give you my opinions of Daniel Holtzclaw's guilt or innocence. I want to qualify that opinion, but more than that, I want to provide insights into the case that were never reported and never considered by a public that has been all too eager to redefine Daniel Holtzclaw as the poster child for decades of abuse against minorities, by those with not only the ability to do so, but presumably an almost unquestionable authority to do so. In this article, I intentionally stay away from theories, race, backgrounds, jury makeup influences, and the whys, except where evidentiary. I want to limit this article to just the facts as they appear in discovery documents, were presented in open court, and have been revealed since the trial. Not long after Daniel Holtzclaw was arrested and criminally charged, I was called and asked by his defense lawyer, Scott Adams, to take a look at his case and to give him my opinion. That conversation went something like this. Scott Adams, paraphrasing. So how badly have you roasted my client on your website? And that would be Daniel's lawyer. Brian Bates, actually I haven't yet. I was waiting for some of the details, but it's coming. And Scott Adams says, I'm sure it is. Before you do that, I'd like to ask you to look over some of this evidence and give me your gut reaction. My guy claims he's completely innocent, but you know how that goes. You may know some of these women, and you may be able to give us some insights as to why they'd make these accusations if they were not true. Or maybe my guy's guilty, and you can convince me of that. In that case, I may need to focus on a plea. At the time, I was known for an advocacy website I ran that often highlighted police offenses and those who victimized some of the most vulnerable amongst society. I've known Mr. Adams both personally and professionally for several years. I've worked directly and indirectly on many of his cases. I first formally met Mr. Adams when I hired him in 2005 to successfully represent me when I, too, faced false accusations by multiple female accusers and the wrath of Oklahoma City Police Vice Lieutenant Doug Kimberlin and then Oklahoma County District Attorney Wes Lane, both of whom care very little about truth nor justice. In the end, my female accusers were shown to be liars and the original charges were all dismissed. That experience and the work I did on my own case convinced me to become a licensed, armed, private investigator in the hopes of helping others in similar situations. I currently own and operate Bates Investigates PI agency. After looking over the evidence available at the time, I told Mr. Adams that though I had no idea if Daniel was innocent or guilty, I did not believe there was anything at that point proving Daniel Holtzclaw had committed any crime. In fact, I agreed with Mr. Adams that much of the investigation seemed premature, biased, and greatly flawed. My next step was to meet with Daniel Holtzclaw in person. Unlikeliest of allies. Upon meeting Daniel Holtzclaw for the first time in Mr. Adams' office while Daniel was out of jail on bond, his first words to me were, "You know they taught us about you in the police academy." An unflattering reference to my 20-plus years of high-profile activism spotlighting street prostitution and human trafficking in Oklahoma City through my website, johntv.com, and numerous local, national, and international television appearances. Activism that often has me harshly criticizing police and the Oklahoma County District Attorney's Office. Daniel Holtzclaw is over 6 feet tall, 270 pounds, and has an air of self-confidence that comes with such a massive physical frame, a badge, a gun, and all the authority granted to law enforcement. To be honest, upon first glance, Daniel Holtzclaw embodied just about every negative stereotype of a police officer that I held. He was white, although he's actually half Japanese. He obviously spends a lot of time at the gym, is cocky, and in his mind, the ends justify the means when you're a police officer protecting the citizenry from the scum of the city. But as I spent those first few hours going over the case with Daniel, I realized something far more important. Daniel Holtzclaw truly believed in his innocence, and in the judicial system he placed his life on the line to every day to protect. I've worked on many cases with truly guilty sexual assault predators. In all of those cases, there was this inexplicable sense of doubt upon hearing their version of events, and the involuntary feeling of the hairs beginning to stand up on the back of one's neck, simply by being in the same room with them. That never happened once in any of my interactions with Daniel Holtzclaw. After meeting with Mr. Adams, then with Daniel, and finally with Daniel's father, Eric Holtzclaw, who is a lieutenant with another police agency in another city in Oklahoma, I was asked to officially assist in Daniel's defense. Do I think Daniel Holtzclaw is guilty or innocent? Since I was asked to be part of Daniel Holtzclaw's defense team, I have spent literally hundreds of hours with Daniel, his father, his mother, his sisters, his friends, and his then girlfriend. More importantly, I've read, watched, and listened to every piece of evidence and potential evidence in this case. I also visited each and every alleged crime scene on multiple occasions, and I did so with the understanding that if at any time it became clear Daniel Holtzclaw was guilty of even just one single crime, that I would bow out of the case altogether. The fact that I assisted in this case through the entire trial and literally sat with Daniel Holtzclaw in his jail cell until only an hour before his guilty verdict was announced should make my opinion crystal clear. I do not believe Daniel Holtzclaw is guilty of the crimes he was charged with and later convicted of. Do I know with 100% certainty that Daniel is innocent? No. The only people that know that are Daniel and his accusers. What I do know is the allegations against Daniel Holtzclaw are highly suspect, and the investigation, prosecution, and trial were far from what was depicted by the local, national, and international media. My critics will say that, why, of course you think he's innocent. You were hired to be part of his defense team. You are biased. I do not hold that opinion against my critics. I am most certainly biased, but that bias was not created as a result of blindly supporting Daniel Holtzclaw. My bias is a direct result of reviewing every piece of evidence in this case. My bias is also formed by many aspects of this case that should trouble every citizen that could one day find themselves or a loved one in the crosshairs of a judicial system that is being pushed along by a public hell-bent on convicting a man with such questionable evidence. Regardless of bias, because we are all guilty of having one, that doesn't change these concerning facts. So, first fact right here. No prior history. Directly from the jury trial transcripts. Defense attorney Scott Adams also be a fair statement to say that during your investigation you were unable to locate any third party whatsoever of any nature that would say that they ever witnessed Officer Holtzclaw do anything inappropriate. Detective Rocky Gregory. That's correct. Daniel has not a single moment in his past that supports the assertion he is a racist or an abuser of women to any degree, sexual, physical, emotional, or otherwise. Investigators interviewed people Daniel had contact with while living in Oklahoma City and working for the Oklahoma City Police Department. When those interviews failed to produce any negative sentiments towards Daniel, they next went to his college town just outside of Detroit and then to his high school hometown of Enid, all with the singular purpose of finding anyone who would cast a shadow over Daniel's character. Try as they might, they couldn't. Not a single ex-girlfriend, classmate, teammate, one-night stand, co-worker, not even an acquaintance. Nobody would say Daniel was anything but quiet, respectful, kind, and focused on his girlfriend, career, and his physique. Prosecutors went so far as to send investigators to the gym where Daniel and his girlfriend worked out, specifically to try to prove he was cheating on her. A witch hunt that proved to be completely untrue, but is a common tactic of immoral prosecutors and investigators. You want to put pressure on a defendant, cause turmoil on their support system. You see, Daniel's girlfriend at the time wasn't just any supporter of Daniel's. She was also the sister of a prosecutor in the very office that was seeking to imprison Daniel for life. This reality enraged the prosecution, so much so lead prosecutor Galen Geiger could not contain his hatred during Daniel's girlfriend's cross-examination, going so far as to admit to the jury he was being unnecessarily crude with her. So, what I want to point out about this one here, folks, is number one, when you hear it talking about the fact that they were going into Daniel's past, looking for anybody that would, say anything bad about him. I mean, that's what they were doing with Stephen Avery, right? Or where they go into the gym and try to prove in front of his girlfriend that he's been cheating on her. You see, and things like that. I mean, isn't that like what they were trying to do by driving a wedge between Stephen and Jody? Same tactic, same BS tactic, right? Then adding to that, you look in the fact that they were so desperately going and looking into his past and everything, right? But they didn't find anything. There's nothing in this guy's past. If you guys recall, in my recent interview with Amanda Knox. After my interview with Amanda, I have a discussion with retired FBI agent Steve Moore, where he points out the exact same thing about Amanda. Here. Yeah.
Oh. Didn't happen. She never stabbed anybody in her life.
Right. Absolutely. And I think maybe we'll get into this, but she's actually, she's got nothing in her past to suggest anything like this kind of behavior, right?
No, and there's a lunatic fringe in Britain mainly, and you'll know them because they won't identify themselves, and that's usually a sign that maybe I'm spouting BS. But they say that she was a criminal. They say she was all this. No, right. She wasn't. She was working 3 jobs to pay for this because her family isn't wealthy, and to go to Italy, she had to work 3 jobs all year to get enough money to go to Italy. That she graduated with honors. She went to high school. When she graduated, they had to create an award for compassion because they felt she so deserved it. And guess what? They didn't have one, so they created one so they could award her with that.
For her, wow.
This is the girl who went over and slashed her girlfriend to death because she wouldn't sleep with a stranger.
It's very difficult. Yeah, it's very difficult for somebody with that level of compassion to become a killer. I agree. It's just not heard of. I agree.
John Douglas, the famous profiler, from Mindhunter and all this kind of stuff.
Oh, yeah.
He worked with me on this case. Actually, I was privileged to get to watch this man work. Right. And he and I worked together. I got the data and provided it to him. He reviewed the data of Amanda's personality from a profiler standpoint. And he said she was likely one of the least likely persons he had ever reviewed to be violent.
Sure. That came out in my interview with her, actually, too. Victim profile created out of thin air. According to the detective's own formal reports, within 24 hours of Janie Ligon's initial complaint, investigators assumed there must be additional victims. To find those victims, Lieutenant Timothy Munsey of the Oklahoma City Police Department arbitrarily had detectives compile a list of all black females with a history of prostitution and drugs, even though Liggins herself had no criminal conviction for drugs or prostitution. Detectives Kim Davis and Rocky Gregory then began randomly contacting women on that list. The list soon took on a life of its own and became known by the prosecutors and the media as Daniel's perfect victims. Yeah, they basically went and found people in that he had contact with as an officer in the past, and to see if they would say negative things about him. Okay, so what can I say about that investigation method? It's stupid. It's like the stupidest thing ever. Are you kidding me? I mean, well, let's walk through that for a second, would you? I mean, here, let's go through that here, all right? So, one person, one female in this case, comes in and claims that Officer Daniel Holtzclaw raped her and, you know, that sort of thing, right? And did inappropriate things, right? Right, okay. The strange thing here, and this hasn't escaped me because as I go deeper into this case, I'm going to obviously find probably the reason for why this happened. But one victim comes in claiming that Daniel Holtzclaw raped her or whatever happened, right? And the officers there, his own, you know, brothers there at the department, right? They immediately think, oh, there must be more victims. What? Like, really? Without even investigating whether or not, I mean, without even doing any testing, without even trying to find out if, in fact, the first, you know, allegation, we'll say, was true, without even investigating that, you're already thinking there's others. See, to me, that leads me to believe there was an agenda. And for some reason, some officers wanted to get rid of Daniel. And I'm not sure what that reason might be because, like I said, this particular paper is only dealing with the facts. And I am continuing to learn more about Daniel's case. But I know that the explanation behind that isn't good. I mean, it's not. Well, I mean, that's a lot to assume when they haven't even done any checking up at that point, really. So, no. We'll see later, but that's a bad, I mean, for me, and even if it is true, even if her claim is true, the fact that she is not a prostitute, it has no prior convictions for drugs or prostitution, and that sort of stuff, yet they went out looking for women that were African American, history of drugs, and prostitution. Even though the original complaint came from somebody who was none of those things, or at least had no convictions. Right? That's pretty crazy. I mean, why did they choose those particular aspects if the original victim that came in to make the complaint was not a prostitute and was not a drug addict? I mean, it's just, that's a weird leap. That's a really weird leap, considering, like I said, they didn't really look into the claims, apparently, being made. They just immediately assumed there were others and started looking into people he had come into contact with in the past. So, I don't know, that's weird. That's weird. So I just wanted to point that out, how very, very odd that is, and how that investigational tactic or technique or whatever you want to call it is just stupid. Of course, those women who he probably had, you know, contact with and had to either arrest or maybe give a ticket or something unpleasant that probably pissed that person off, and then you come back later asking that person if, you know, if they've ever been raped by a police officer or whatever, right after Daniel Holtzclaw's face has been pasted all over the press. You know what I mean? It's like, what? I mean, it's just the tactics you'll see here. It's the way that they got the statements from all the women is just extremely, extremely hokey and wrong. And I believe this, I mean, like I say, this investigational technique is just stupid. You know, doing it that way. Of course, most of those people are going to be inclined to say something negative. You know, I mean, human nature. So, anyways, all right, moving on. That sounds like a great investigational technique. I wonder which school they went to that taught them that one. At jury trial, the prosecution denied the physical existence of this list. I contacted Unit 800 and had the supervisor, Janet Mansfield, look up all of the females that 2C45 ran through them on April of 2014 to June 18th of 2014. She gave me a list, and I began checking the names through our Varuna system to see if any of the persons checked had a criminal history. I was specifically looking for women who had either a drug history and or a history of prostitution. I then made a list of women who I felt we needed to make contact with to see if they were a victim of sexual assault. We then went back and expanded our search and went all the way back to January of 2014. So they just kept expanding the search backwards into the past to try to find more people that they could go to talk to potentially try to find dirt on Daniel. I mean, and this is their method of seeking truth. The footnote there, by the way, is interesting. Lieutenant Timothy Munsey suddenly retired in 2019 after reportedly being on administrative leave and being asked to come in for an internal affairs interview regarding how he handled an undisclosed sexual assault investigation. So isn't that interesting? That he was one of the cops involved with going after Daniel here, and then Internal Affairs was looking into him for something to do with sexual assault investigation. That's interesting. The interrogation. When Daniel was confronted by investigators within hours of Janie Ligon's allegations, he was completely open and cooperative. He never tried to lawyer up, repeatedly expressed his desire to cooperate, offered to take a polygraph, signed waivers to allow investigators to take his DNA, his uniform, search his phone, private vehicle, and apartment, even when confronted with the fact that investigators had surveillance video of the Ligon's traffic stop. Daniel's version of events never wavered and matched the video and physical evidence exactly. Sound like somebody else we know, folks. Stephen Avery. Who also didn't lawyer up. He was up at Crivets, and even though he had lawyers already because of his civil suit that was going on, but they weren't up at Crivets, and he continued to talk to the detectives up at Crivets, even though his lawyers wanted him to stop. But Stephen continued to be nothing but cooperative. When Colburn and I believe Remaker, I think, show up at one point, or anyway, when the officers show up at his house and ask if they can go and look in his trailer, he let them do it. He was never trying to hide anything. He's being very cooperative, very similar to what we see here with Daniel Holtzclaw. So I just thought I'd point that out. No need to search. Even though Daniel Holtzclaw consented to allow investigators access to all of his clothing, personal vehicle, personal cell phone, computers, and apartment, detectives Davis and Gregory never chose to exercise those options. When Daniel turned over his uniform during his interrogation, seasoned sex crimes investigator felt there was no need to take Daniel's underwear into custody for testing, even though he had allegedly committed a rape only hours before. Okay, so here's another one that's just inexplicable. I mean, are you kidding me? Why would you have not taken his underwear? Right? What? You're okay. Somebody comes in and claims that Daniel Holtzclaw committed a sexual predatory act, or whatever you want to call it. I mean, a rape, forced sexual act, whatever it may have been. But you have somebody that comes in and says that, and you take the pants, but not the underwear. I'm not that. I mean, that makes zero sense to me. Why would you do that? Why wouldn't you take the underwear? Okay, and what's even more odd, I mean, think about that. I mean, if let me put it this way: how much doubt would there be if there had been some semen in Daniel Holtzclaw's underwear? Think about if there wasn't. And maybe that's why the underwear didn't get collected. If you think about that for a second, you understand what I'm saying, right? Okay. For those of you out there in the world who have engaged in the sexual act, and I'm going to try to keep this from being graphic, but those people out there in the world that know about that know that after sex, the male organ decreases in size. Okay? It decreases in size, and as it decreases in size, there's still some fluid in the urethra that ends up pushing out as it decreases in size. So, if he was... I have to point this out because it's so inexplicable that they didn't take his underwear. So, to point this out, why this is a problem, if he is supposedly raping a female accuser, right? Then he's going to be pulling his, male appendage through the underwear as well, or over it. One of the two. He's got to get past that as well. Okay? So, and after he's done, when he tucks back in, as his appendage continues to decrease in size, it would have put some of his own semen or seminal fluid in his underwear. That would have been pretty convincing, actual, real evidence. So I cannot explain why they didn't take the underwear unless it was a calculated move, because they were afraid of finding nothing there. I don't know. That's a potential theory. I guess I will say, but it's such an inexplicable thing that to me that's really the only sensible explanation that would explain such a very odd thing. I mean, to not take the underwear in a potential sexual assault, and to deem that wouldn't have been, that's just odd. I don't know, anybody else agree with me on that? That's just strange for potential sexual assault. So anyways, all right, here we go. A allegation that was later revised to 3 rapes within hours of each other. Additionally, these same seasoned investigators never searched Daniel's personal vehicle, never searched his cell phone, and never searched his apartment or personal computers. Detectives didn't even request his additional uniform, shirts, and pants that were hanging in his closet and laying in his dirty clothes. GPS evidence. Investigators and the public have made a huge issue out of the GPS, referred to as AVL, Automatic Vehicle Location, evidence as proof Daniel Holtzclaw assaulted his accusers. In reality, the AVL is only useful in a criminal proceeding in 2 applications. 1, if Daniel denied coming into contact with any of his accusers, which he does not. Or 2, if the AVL shows discrepancies in the assertions by Daniel's accusers, which it does. Despite what was reported by the media in several instances, the AVL data directly discredits the allegations of Daniel's accusers. In one instance, an accuser, Sherry Ellis, says she was taken to an abandoned schoolyard, removed from Daniel's patrol vehicle, bent over and raped for 10 minutes. Daniel's AVL clearly shows he only drove past the schoolyard, never stopped, never drove slower than 2 miles per hour, and was only briefly in the area. In another instance, an accuser, in other words, couldn't have been there for 10 minutes raping her because he was in the area less than 10 minutes and didn't stop. In another instance, an accuser, Regina Copeland, claims Daniel followed her home, parked in front of her driveway, told her to get into his patrol car, and that he then made 3 right turns before pulling over, removing her from the patrol car, and raping her. Daniel's AVL clearly shows he never even drove down her street. In reality, the AVL proves Daniel was doing his job, patrolling his designated area, and coming into contact with citizens in that area. As pointed out by Scott Adams, Daniel's trial attorney, The hardest lie to uncover is one that is inserted into an otherwise very real story. If AVL is proof of a sexual assault, then every police officer is open to a similar accusations and criminal prosecution by anyone they come into contact with while on patrol. And I think that this being obviously this AVL evidence that's being ignored is very similar of Teresa's cell phone tower pings, and the evidence of her leaving Avery Salvage gets ignored. So I think that's another, kind of similarity here, where prosecutors are definitely picking and choosing, what they want in order to build their narrative. So I think that's interesting. 13 women couldn't all be lying, right? Investigators and the public frequently point to the sheer number of similar accusers who all had seemingly similar accusations. This seems pretty damning on the surface and was exploited to the fullest in the local and national media headlines. However, the similarities lose their punch when you realize the only reason the accusers have the same profile, black females with a history of drugs and prostitution, is because those are the only people investigators went out looking to interview. Additionally, as supported by the audio recordings and the police reports of those interviews, investigators told the women up front, and even told their family members and loved ones, that they believed they may be a victim of a sexual assault perpetrated by a police officer they had contact with in the recent past. This, even after the allegations against Daniel and his face had been shown in the news, right? So they were not going to have much trouble guessing at what cop to say had committed the sexual assault, right? If you only interview women who fit a particular profile that you completely made up, and you tell individuals up front what type of information you're looking for, inappropriate sexual contact, then you're creating a self-fulfilling prophecy. Investigators and the prosecution knew their case was only strong if they piled on victims, even if those victims' allegations were shown to be lies. More accusers shown to be uncredible than credible. The public has been told of the 13 Daniel Holtzclaw accusers that resulted in criminal charges. They are even often referred to as the OKC 13. What the public hasn't been told is that there were actually 21 accusers in total, and that 62% of all accusers were found to be not credible. That's right. 8 of 21 total accusers were eliminated almost immediately because they claimed to have been assaulted after Daniel had already been placed on administrative leave and had been relieved of his badge, gun, and patrol car. 8 victims claimed that he had raped them on duty after all those things had been taken away from him. Right. Okay. Most of whom later admitted to police they lied. Of the 13 remaining accusers, 5 were not believed by the jury and resulted in acquittals. 8 plus 5 equals 13 women who either eventually outright admitted they lied or were dismissed by the jury. 13 of 21 is 62%. So that's 62% of the original accusers against Daniel Holtzclaw didn't hold up in court. Even if he didn't rape nobody. Investigators and even Oklahoma County District Attorney David Prater would have you believe that the only reason 18 of the counts and 5 of the accusers' assertions were denied by the jury was because there simply wasn't enough evidence to prove guilt beyond a reasonable doubt, and that those women were victims nonetheless. That assertion is misleading and untrue. In reality, the evidence for all of the accusations by all of the accusers was the same. They came into contact with Daniel Holtzclaw while he was on patrol, and he committed a sexual assault upon them. No independent third-party eyewitness and no direct evidence existed in support of any of the criminal charges. The accusers that were denied their assertions were done so because they were proven to be liars by the defense. Take the example of one of the most high-profile accusers, Shardrian Hill, or Shardaron Hill. Her story has been retold hundreds of times by the media. It's pretty damning stuff. Daniel allegedly sexually assaulted her, Hill, while she was high and handcuffed to a hospital bed days after he friended her on Facebook. He engages her in direct messages and phone calls. Daniel even admits to going over to her house, where Hill claims that she was assaulted again. Yet, all of her charges, 6 total, Daniel was acquitted of. Why? Because she lied. Hill's account of being raped in a recovery room of a busy hospital emergency department is ludicrous. When confronted with the reality that none of her Facebook conversations with Daniel contained even a hint of sexual contact, consensual or otherwise, she claimed under oath that he knew better than to put it into writing, and he only talked inappropriately to her during their phone calls. However, phone records clearly showed the phone calls were limited to 2 5-second calls, most likely never answered by the other party. The bombshell came when I located a video and audio recorded interview of Detective Rocky Gregory interviewing Hill. After the interview was over and Hill was outside the interview room, she made this statement she didn't know would be recorded. Is this good evidence? Even if he didn't rape nobody, he's still getting in contact with people he's arrested. Hill had just spent over an hour describing how she alleged Daniel repeatedly sexually assaulted her. Yet, she doesn't say, even if he didn't rape those other women. No, Hill clearly says, even if he didn't rape nobody. Hill's allegations resulted in 6 criminal charges. Daniel was acquitted of all 6. Not because there wasn't enough evidence of guilty, but because there was overwhelming evidence Hill lied under oath. Despite her allegations not being believed by the jury, Hill is still often paraded before the media and the public as a victim. Hill has a pending federal civil lawsuit where she hopes to collect millions of dollars. Investigative coercion. Investigators clearly coerced women into becoming victims and making allegations against Daniel. 2 striking examples of this were with accusers Terry Morris and Carla Raines. Morris insisted that she was attacked by Daniel while on foot and en route to a homeless shelter in downtown OKC. Morris stated that Daniel was driving an older model police car. Morris was also shown a photo lineup containing Daniel's photo. The problem with Morris's assertions are that Daniel didn't patrol near the homeless shelter. His AVL never showed him by the homeless shelter. He was driving a new model patrol car during his time period, and Morris picked out a different police officer in the photo lineup as her most likely attacker. Those facts didn't dissuade Detective Rocky Gregory from spoon-feeding Morris details about a new time frame and location for her assault, intentionally making it match the existing AVL records for Daniel. Morris initially resisted Detective Gregory's attempts to get her to change her story. Only after she was arrested and sitting in jail on an unrelated charge did she contact Detective Gregory and change her story to match the one that he had suggested. Daniel was acquitted of her allegations. Carla Raines was also approached by Detective Gregory. Raines spent the first several minutes of her interview denying ever having any appropriate contact with any police officer. However, she did admit the only officer that she had contact with in the last year was Daniel, though she didn't identify him by name. Only after several minutes of persuading Raines to declare herself a victim, after referring to Daniel as a really bad guy with lots of victims, did she take the bait and implicate Daniel. Detective Gregory never noted in his official police report that Raines had denied being a victim 7 times. When asked at trial if her denial was significant and should have been noted in the official report, Gregory said no. Defense attorney Scott Adams told the jury that Detective Gregory either had an agenda or was incompetent. Daniel was acquitted of her allegations. Much has been made of the case involving the only minor to make allegations against Daniel Holtzclaw. Adara Gardner, 17 at the time, was the only accuser where DNA played any role in the investigation. The prosecution and the media played up the fact that Gardner's DNA was found on Daniel's uniform pants, on the outside and inside of the fly, to be exact. In all honesty, that's all most people had to hear to determine Daniel was guilty in their minds. I have to admit, I thought it was pretty compelling evidence at first too. However, the police department's own DNA lab expert, Elaine Taylor, clearly testified the DNA, which was found in such a small quantity that it is defined as trace DNA, was speculative at best. Under oath, the prosecution's expert admitted that she never tested for bodily fluids like semen or blood, which would have been key, because if it had been vaginal fluid, that would have been a big deal. So I'm not sure why they never tested for that. Taylor admitted that she never had fluoresced Daniel's uniform pants for any indicators of fluids like vaginal fluid. Taylor only tested for common skin cells and only tested the fly of Daniel's pants. The prosecution's DNA expert confirmed at trial that they have no way of telling from what part of Gardner's body the DNA came from, how it got on Daniel's pants, or even if Gardner actually ever made physical contact with Daniel's pants. The prosecution's expert agreed that Gardner's DNA could have been transferred to Daniel's pants by a secondary transfer. That's how small the amount was, that it could have been put there by a secondary transfer. The prosecution's own expert saying that, meaning Daniel could have gotten Gardner's DNA on his hands when he either did a pat-down search of her or was searching through her purse. Daniel could have then transferred that DNA to his pants via his own hands while he was going to the restroom, obviously sometime that night, adjusting himself or simply tucking his shirt in. It's also important to note that Daniel allegedly raped 2 other women within hours of Gardner's rape, and those women's DNA are not located on Daniel's uniform. Not only is the DNA evidence in Gardner's accusations not conclusive in any way, Gardner's own mother reported to investigators that Gardner's only response to her on the night of the alleged rape was that she had met a hot cop. Gardner's mother had also filed a missing persons report on her daughter earlier that day and signed a battery complaint against her for punching her in the face. At trial, Gardner's mother denied the hot cop comment, even though her interview was recorded and played back to her. The mother even denied signing an assault complaint against Gardner, even though the signed complaint was presented at trial. As if the above information wasn't enough to cast doubt on the criminal implications of Gardner's DNA, there was a huge revelation after the trial. Closer examination of the DNA testing done by Elaine Taylor with the Oklahoma City Police Department revealed that Taylor had also found male DNA in the same spot of the fly on Daniel's uniform pants. That male DNA was tested by Taylor and determined not to belong to Daniel. Despite this realization and the fact it further supported the defense's theory of simple secondary transfer DNA, neither Taylor nor the prosecution revealed this discovery at trial for the jury's consideration. Prosecutor Galen Geiger lied to the jury. Lying by a prosecutor to a jury is a serious matter. Doing so intentionally and with malice by a prosecutor reeks of disdain for the entirety of the criminal justice system he or she has sworn to protect. That said, that's exactly what Oklahoma County Assistant District Attorney Galen Geiger did when he uttered these words to the jury. I would suggest to you that the most important thing about Adara Gardner is the fact that DNA from the walls of her vagina was transferred in vaginal fluids onto the outside and inside, not of his pockets, not of his cuff, not where he sits, but of the exact location she says his penis came into contact. Those words were grossly sharp in contrast to the evidence and testimony as presented at trial, despite the prosecution's own DNA expert testifying that there was no way of knowing how Gardner's DNA was transferred to Holtzclaw's uniform, Prosecutor Geiger made certain his lies were the last thing that the jury heard before they engaged in their deliberations. It should come as no surprise that jurors have since commented publicly that it was statements made about the DNA that heavily impacted their verdict. Now, this one here is very, very much like what happened with in the closing arguments for Brendan Dassey. You see, this thing where prosecutors like to go ahead and say something in their closing argument that isn't really true here. He has no proof that there's any vaginal fluid in any way that came out. They had no proof that it came off of Adira Gardner's vaginal walls. That's the DNA. Their own DNA expert said that, and testified. But yet he went ahead and said that in his closing arguments anyway to the jury, right? The other thing is that he says in there that it wasn't in the pockets or on the seat of his pants or anywhere else. But if they didn't test those areas, he can't say that either. I mean, so that statement is really, really, bad. And that's very similar to what we're going to see with Tom Fallon here in the closing arguments of Brendan Dassey's trial.
People who are innocent don't confess. The defendant confessed because he was guilty, because he did it.
So, for anybody out there that may not have been studying wrongful convictions at all, that statement you just heard from, at the time, Assistant Attorney General of Wisconsin, Thomas Fallon, okay, that statement is demonstrably false, and he made it in his closing arguments to the jury at Brendan's trial. Okay, so why is that statement false? For those of you who don't have a real knowledge of wrongful convictions, and maybe haven't studied much of the stats that come out of the Innocence Projects, I can tell you that of the cases, all the cases that the Innocence Projects where they've exonerated an individual who was a juvenile with mental limitations, okay, of all the exonerations of that type, in cases where there was a confession, 8 out of 10 of these mentally limited juveniles, 8 out of 10 would give a false confession. It's a stat for you. 80% of kids like Brendan falsely confess, according to the stats. Thomas Fallon knows that. He knows that, and he said it anyway. He said what he said there anyway. Okay? So, all right. Just wanted to point that out. That's the damaging type of things that prosecutors can do because they get the last shot at the jury. Okay? And the problem, it's not necessarily I blame them for trying. The ones I do blame is the judges for letting them. Okay? Because the judges are former prosecutors most of the time. And 95% of the time, prosecutors are able to get away with lying like that in their closing statement. The last thing the jury's going to hear, besides from the judge, before going into the deliberation, and you get to see lies like that, and lies like you saw in the closing arguments in the Daniel Holtzclaw trial. They had no proof it was vaginal fluid, and if they didn't test any other areas of the pants except for the fly, and they didn't take Daniel's underwear, what? Right. So that's the kind of damage. That's the serious business it is when prosecutors are allowed to lie in their closing arguments. So, there we go.
People who are innocent don't confess. The defendant confessed because he was guilty, because he did it.
My rapist was a short black man. I've given examples above where 3 of Daniel's accusers were shown to be liars and he was acquitted of their allegations. In addition, there were 2 more accusers who were also shown to have given false, inconsistent, or unbelievable testimony. And Daniel was also acquitted of all their allegations. Carla Raines and Florine Mathis. This fact may cause many to feel that the jury system fulfilled its role and weeded out the truth from the fiction. Unfortunately, that was not the case, and I'll make that point with a single last example. Accuser, now officially a victim, Sherry Ellis, claims that she was forced to perform oral sex on Daniel after he stopped her and fondled her breasts, buttocks, and vagina. Ellis then claims that Daniel drove her to an abandoned schoolyard, removed her from his patrol car, had her bend over, and vaginally raped her for approximately 10 minutes before letting her simply walk away. Sounds pretty horrific, doesn't it? And the jury believed it and convicted Daniel of the charges related to her allegations: 2 counts of a sexual battery, forced oral sodomy, and rape in the first degree. But here's what you probably never heard reported by the media. Ellis literally couldn't recognize or point out Daniel as her attacker at the preliminary hearing. Ellis was the only accuser not to be asked by the prosecution to point out her attacker at trial, because of her inability to do so at the previous hearing. AVL GPS evidence from Daniel's patrol car does indeed show him traveling to the abandoned schoolyard. However, the AVL device records an officer's speed, and it never shows Daniel driving slower than 2 knots, let alone stopping for 10 minutes to rape someone. And lastly, the most likely reason Ellis couldn't pick out her attacker in the courtroom is because she told investigators and testified at trial that her attacker was an officer that is routinely patrolling her neighborhood and that he is a short black male. In contrast, Daniel is over 6 foot tall, pale. Despite all of those flaws in Ellis's investigation, Daniel was convicted of the crimes against her. If it's so clear to me that Daniel is most likely innocent and that reasonable doubt abounds in this case, then why was he convicted? I still wrestle with that fact. That is one of the reasons I held back from reporting on Daniel's case at all until after his sentencing, and after I had a chance to process everything that I had witnessed. My professional obligation to Daniel as part of his defense team has ended, but my support for his innocence and my determination to expose the injustice of his investigation and the prosecution are unwavering. I literally just left Daniel as he paces in a cold cell on the top floor of the Oklahoma County Jail. Daniel waits as he is set to be transferred into the prison system in Lexington in less than 24 hours, where he will be profiled by other inmates and guards as a former gang officer who used his badge to commit horrific acts against minority women who most likely have direct ties to inmates in whatever facility Daniel will eventually be housed, most likely for the rest of his life. If you are one of those who wished unimaginable harm upon Daniel, your desires will most assuredly be Daniel's reality, a reality that could befall upon you or any of your loved ones. So this is Daniel with his parents. This is a Facebook post from March 16th of 2014. In summary, I worked on this case for countless hours, while nobody, outside of Daniel and his accusers, can definitely say these crimes did or did not happen. I can say with 100% confidence justice was not served and that Daniel was not proven to be guilty of a single crime. What happened in that courtroom should cause everyone to fear the jury system as we know it and remind the citizenry that prosecutors are not seekers of justice. They prosecute. That's all they know, and they often do it regardless of truth. Daniel did not choose the perfect victims. I submit to you that prosecutors picked the perfect accusers. I believe Daniel to be an innocent man, and Daniel's story should be told. So, just a little note down here that he adds, there is much more that casts doubt on Daniel's guilt and points to a flawed investigation. In this article, I intentionally stayed out of the race issues beyond what was directly evidentiary in nature. I also stayed away from the victims and their background, except where necessary for evidentiary purposes. I also intentionally did not include any theories as to why any individuals or agencies acted in any particular way and what their motives may or may not have been, including Daniel, investigators, accusers, jury members, and more. I wanted this article to be only about the facts and evidence as it existed at trial and was presented in open court. Theories are for another day and often bias readers.
So, as you can tell, I see a lot of issues here with the Holtzclaw case. I'm not going to say 100% certainty that right at this point of whether Daniel is guilty or innocent, but I can tell you, judging by what I'm seeing here, the way that this was done, the way the evidence went, the way the fact that one conviction stuck when it's pretty obvious he couldn't have done it. I mean, literally. I mean, the car never stopped. So what am I supposed to... Okay, so not only does he have AVL, but he also has like that thing that Homer Simpson has in The Simpsons when he becomes a truck driver. And like, so the patrol car, he just slows down to 2 miles an hour, jumps out of it, pulling Miss Ellis with him, takes her over into the schoolyard while the car goes and drives it around. It's for a little while or something. Oh wait, there's another problem with that. There's another problem with that. His car wasn't in the area for 10 minutes. So how could he have been raping somebody for 10 minutes? And that stuck. That's pretty interesting. That's, as I look into more of the circumstances of the trial, I'm sure it's going to be intriguing. As I've already said before earlier in this video, I already know there's something going on between the officers involved here. It would seem pretty clear that there was some kind of desire or agenda to bring down Daniel. I mean, I can't understand their decision making in this. It's, to me, completely different than I would normally see police officers act. And then when you couple that with the fact that so many of these allegations fell flat on their face and were obviously untrue, and one of the ones that stuck is obviously untrue. So we'll be looking into the remaining ones that stuck, obviously. That's the ones I'm going to be very, very interested in. But this was, I thought, a good place to start because it was factual and it was trying to stick to the facts, and it obviously wasn't giving me that narrative that helps me to explain why these officers made such a quick judgment and suddenly decided that Daniel had done this to others, and how they made these leaps. You know what I mean? So it'll be interesting to see how they made these leaps, because no matter what, I mean, I feel there's no excuse for the way that they went about this investigation. I mean, self-fulfilling prophecy is exactly the right terminology. That's what they went out and created. They went out and created a bunch of self-fulfilling prophecies, and when it wouldn't prophesy itself, they started throwing these ladies in jail for other charges until they were ready to play ball. And then they would come back with a story and implicate Daniel. So that's a problem. That's a problem. And when you see those tactics from the prosecution, like lying to the jury in their final argument, I mean, over and over, the way that they went looking into Daniel's past, they went to his hometown where he grew up, looking for people that were willing to say bad things about him, and they couldn't find anybody. That's a similar situation with Amanda Knox. She has no criminal past. She didn't have anything in her past to indicate anything that she was capable in any kind of way of the type of thing she got accused of in Italy. And so when you see the desperation here of them going back to Daniel's hometown where he grew up to try to find people who are willing to say negative things about him. I mean, that reminds me of Stephen Avery a bit. with the way that the investigators were acting with Stephen Avery when they were going over to when they were going over to Jody, who was in lockup, and they're asking her about her and Stephen's sex life, how many times a day they were having sex, and then trying to get her to say, wasn't that a lot? Wasn't he hurting you? So after asking about the sex life, then they tried to suggest that Stephen was hurting her and everything. She was like, no, we were both into it. You know, it's like there's that type of thing where they were looking for negative, right? And that's essentially what they were doing with Daniel. That's pretty sick, going all the way back to his hometown where he grew up, trying to find, people that would say, the kind of horrible things they wanted people to say to help their case. Yeah, unbelievable. So, you tend to see the same indicators or earmarks in wrongful convictions, and that's kind of what I'm trying to point out here. Obviously, there's still, we're obviously, there's still some more, research here to be done with Daniel, but obviously, there's a lot here that's in serious question. So it will be interesting to, as I say, look into the remaining accusers, complaints, and see what, if there is validity there. That will be something I'll be very interested in, of course. So, but as it is right now, just looking at the facts as we did here today, I think it was pretty interesting. And like I said, I'm intrigued now to move on, because I really am intrigued to find out what caused Daniel's brothers to turn on him and believe that he had done these things and go out and bully witnesses and fabricate, more allegations. I mean, that's weird, that's strange, and it's alarming. And I'm wondering why that was taking place. So it'll be, obviously, I'm sure it'll come out as we move forward with Daniel Holtzclaw. I hope you guys all found this video interesting as we continue to look into wrongful convictions and potential wrongful convictions as we are looking into here today with Daniel Holtzclaw. I hope you guys found it interesting. If you haven't already, please hit subscribe, and we'll see you.